Thanks everybody for coming today. I'm looking forward to talking about efficient IP strategies to drive enormous startup exits. So, as a threshold matter, today's talk is actually not going to be that much focused on the legal or tactical aspects of building an IP portfolio. Um, there's a number of connect sections that really talk about the blocking and tackling, the basics of IP, but really this session is going to be talking about what can you actually do with your IP in order to drive value for your business. So why does it matter to my early stage startup? I mean, here at the Swartz Center, there's so many new companies that are developed every year, and that there's so many successful companies. If we look around the room at the posters on the wall, when you're starting from the beginning, it can be sort of hard to see what really is out there at the end game and why it is intellectual property and the related strategies matter to you. And so one of the things that I'd like to highlight is that IP becomes critically important the second you start trying to raise money. And it's becoming more and more important at the seed stage. And so one of the things that you can see from this particular graph at the bottom, and it's a little bit hard to see, is that there's been an increasing trend that companies that actually have patent assets are raising more capital, and they're raising more capital compared to their non-patenting peers. Moreover, the intangible assets of companies are becoming a larger and larger percentage of the value of publicly traded companies. So what this graph will show you is that going back to the 1970s, tangible assets were the majority of the enterprise value in publicly traded companies. But over time, starting in the mid 1990s, that flipped. And today, about 80% of the value of the S&P 500 is actually coming from intangibles, whether it's goodwill and trademarks and brand recognition, whether it's the patents, trade secrets, or other intangibles. That's what's driving the value of your investments in an S&P 500 index fund. And so setting that as the stage for this discussion, how do you exploit that? How do you use that to drive value in your business? Okay, let's see if we can see if we can. And moreover, business objectives are what drives IP strategy at large companies, and it really should be what's one of the drivers of your business strategy at the earliest stages. Thinking about how you can use and develop the intellectual and intangible assets that your company is building is extremely important when you're looking at developing an ROI. And a lot of the things that have been discussed in earlier Connect sessions related to IP rights and developing a portfolio, those things matter as you go and start building out your company. But really, like the way that Sreekar and I look at how you do this and how you use your business objectives to drive the IP strategy, because really it is you as the entrepreneur, you as the business owner that should be driving your IP strategy, not your patent attorney, not really even your investors. You should be owning your company, owning the ideas that are in your business, and making those decisions, because it is a critical aspect of your business strategy. And so really, we look at it as they all should be feeding each other when you're developing and creating intellectual assets. So one other thing to start at the beginning here is that IP value does not come from just filing patents. And I think one of the key things that we looked at was IBM recently changed their patent strategy. IBM, for those that don't know, was the largest patent filer in the United States for decades, and has made substantial money now transitioning from what they used to do as far as a large mainframe and PC business into really being largely developing a lot of their revenue from licensing. Moreover, 75% of organizations worldwide view patents specifically as a driver in their business. And companies that are coming out of Carnegie Mellon are largely technology companies. When you're building technology assets of any kind, patents are important, but really making sure that whatever it is that you're building, that you have the right intellectual property mix that's protecting your assets, being an incentive to your customers and being an incentive to your investors to invest in your business. And so to that end, looking back at IBM's strategy, they really wanted to look at how they can manage their talent, their resources, and how that all plays into the intellectual property and the intangible assets that they're creating. And so, again, these are things that need to be driving your business and not just going out and getting a patent, just to say you have it or to check a box. It needs to be more than that if you want to really exploit and develop your company the right way. And one last thing before we start diving into the details of this conversation. Again, intellectual property is more than just patents, more than just trademark registrations, more than just copyright registrations. This survey looked at what are the top 3 subclasses of intangible assets that are most important to your company. And the range of companies that answer this question is things like your supply chain and your vendor contracts. Hard intangible assets like goodwill, software licenses, internet domains, B2B rights like broadcasting rights, marketing rights, use rights, as well as your brand, other kinds of public rights that even things relating to drilling rights if you're a minerals company, and other kinds of agreements that are non-revenue based, like non-competes, non-solicits, are other things that create barriers to entry and create enterprise value in your company. So with that as a grounding background, what we're going to talk about today is where your IP can actually sink your company, basically being concrete shoes that'll drive your company down. When can you use intellectual property as a lifeline to extend your runway and to develop revenue streams for your business? How to make IP decisions, and how do IP decisions make or affect exits? So looking at how IP can be a concrete shoe or how it can sink your business, getting IP can burn valuable capital. And I think one of the things that I've seen in companies, and I'm dealing with a company right now that is in this space, if you don't manage it properly, you don't think about it through your strategy from the beginning as far as when you're going to outlay your capital and what assets are truly going to be important to your business, you can spend a lot of money on patent attorneys, you can spend a lot of money on filing registrations and applications in foreign jurisdictions that can cost you a lot of money. Because again, patents cost time and money to prepare and negotiate and to prosecute with the various patent offices across the world. Branding and trademarks require effort from your team that may distract them from developing your product or building your business. Trade secrets ultimately require vigilance and policing to make sure your policies are followed, and that you have the contracts in place in order to actually protect them. And know-how requires time to develop and recover. And going along these lines, poor intellectual property habits will also drain additional resources. If you don't build your portfolio properly, poor drafting and not spending enough time to develop your patent applications properly will limit your ability to prosecute and get claims that'll actually be enforceable or actually drive value to your company. If you don't draft your patents properly, you can expose your trade secrets, things that you should have kept secret and that would have given your company more value by not disclosing in the patent process can harm you. Again, IP protection is geographically limited. So that if you're not being conscious and thinking through where it's important to file patent applications and where your revenue and where your competitors are, you may end up missing a large part of the enterprise value of your company. And then beyond this, litigation to actually enforce your rights is expensive. And so making sure that you understand what sort of clearances you need to make sure you have freedom to operate is important, but also thinking through whether filing patents and trying to enforce them or using other intellectual property rights as an enforcement mechanism is actually something that you're going to be able to achieve because it's extremely expensive. The threshold for getting into a patent litigation case is usually north of $1 million if you're going to actually try to go through and take it to judgment, usually multiples of that. If you don't have the resources in internally to be able to fund that kind of thing, it becomes, you may start going down this road and realize that you actually don't have the teeth to enforce it. So looking at it from the other perspective, we kind of walk through and like what kind of mistakes you can make, how that can actually drag down the enterprise value of your company. On the other side, if you do it properly and you think through the business strategies related to the IP of your company, it can serve as a lifeline to help you actually extend your runway, get interest from investors, get interest from customers, and actually drive revenue towards you. So, it really can be a mechanism for allowing you to obtain capital and to encourage business relationships. So looking at how an IP strategy can turn the costs that you're expending both time and money in developing assets, how can you actually turn that into an investment? So when you have a comprehensive IP strategy and you're developing each of these items appropriately for your business, it can encourage investors who are going to do diligence on your company to see that you understand how to run and operate and manage those assets and how they fit into your larger business strategy. It can encourage joint ventures with other companies who want to co-develop or build with you. Because largely, when there is a joint venture, a lot of times there are assets that are put into a shared bucket, including patent rights, manpower, and the like in order to drive that joint venture. Cross-licensing. So when you have a technology and you're building and developing it, eventually you're going to start using and building upon things that other people have used in the past. When you have IP rights and you run into a place where you need to obtain someone else's IP rights, having something to give back to them can be really beneficial in helping you manage and get the best deal that you can for your technology. PR, when you go through and you prosecute a patent application, one of the benefits of it is that it's been reviewed by patent examiners, at least to a certain level. It's been deemed through their review to be novel and not obvious. And it is an indication of quality to a certain extent. It gives you some negotiating power in your discussions, because if you do have a patent right, it's the right to exclude others from making or using your claimed invention. And so if they are using and reading on your technology or potentially reading on your technology, it is an inducement and an incentive to get them to come and negotiate with you. And then lastly, also, to a certain extent, it gives you some sort of acquisition pricing power as well. So digging a little bit deeper into these and what are the different kinds of ways that you can use your assets to help you fundraise. Again, three ways that this could happen is through venture capital, litigation finance, and loan collateral. So in venture capital, particularly if you're in deep tech, hard tech kinds of technology areas, or you're in the life sciences, those venture capital investors, amongst their top due diligence concerns are the way that you've built and managed your IP portfolio. And so in those cases in particular, because it's so high up on the list with a long time horizon in order to see your technology reach the market, they want to make sure that your IP is well developed. Litigation finance. So if you are a patent holder and have other IP rights, and you don't have the sufficient capital in order to enforce them on your own, you can use your IP rights as a basis for finding outside investors to help you fund your enforcement efforts. And then lastly, loan collateral. Patents and other IP rights are a form of property rights, and they can be collateralized and used if you have sufficient revenues tied to them or the potential for revenues in the future as a way to get better terms on debt instruments in order to fund your company. And that's a strategy that's used with some frequency in late stage deep tech and life sciences companies, either to fund bridge financings or other ways to raise non-dilutive capital. So digging a little bit deeper into patents and venture capital, I mean, again, venture capital funds see patents as a de-risking investment. I mean, again, there's been some sort of vetting that's happened at the patent office. It allows you to also not have to deal with non-disclosure agreements in the same way that you would otherwise. You do have a level of protection that someone else isn't necessarily going to be able to go off and steal your idea and take it without giving you compensation. Um, and what's interesting from a venture-backed exit perspective, there have been academic studies that have actually shown that patents, particularly in the life sciences areas, have substantially larger exits when they have better, more developed patent portfolios. And the caveat here too is that it's just like in any other space, it's really important to know what your venture capitalists in your industry and geography look for in terms of your IP portfolio. If you're building a SaaS B2B marketplace, they may be less concerned about your patents, but they're going to be much more concerned about your trade secrets, the way that you're managing your source code, the way that you're building and developing your relationships with the parties that are coming onto your marketplace. And so in that case, patents might not be the thing that they really care about and they want to see. It may be a different form, but regardless, in those cases, your intangible assets are what are going to drive the value of your company. Along these lines too, IP filings are actually correlated in the data with better and more successful exits. The filing of patents and trademarks at the seed and early growth stage is associated with a higher likelihood of venture capital funding. And that's something that we saw at the very beginning, that it's happening even at the earliest seed stages, and that it's been growing. It's much probably more critically important that you're looking at this at the early stages, because you're not going to make it to the later stages if it's important to your business and you're not taking care of it up front. What was interesting in that even in certain geographies, and this is going back to the prior slide, certain jurisdictions around the world are even more cognizant and care much more about your IP rights. So in Europe, for example, European venture capitalists tend to want to invest more in companies that have stronger IP rights. And then lastly, there's actually a correlation with early filings and volume of filings of patent applications with successful initial public offerings. So if that's something that's on your company's timeline, going out into the future, you should be considering and thinking about the ways that you can build and develop the patent portfolio. Along these lines too, there's a 59% greater likelihood that you're going to raise venture capital once you actually have your first patent issue. And I think that, again, this is probably a correlation more than a causation. I don't know that your patent rights are going to cause you necessarily to raise more capital. But if you're capable of going through that process successfully, it is an indication that your company is moving somewhere in the right direction. Again, has some sort of novelty or non-obviousness to the technology that's being developed. You've been able to get enough money and scratch enough money together to pay your patent attorneys, to pay the fees in order to get your patent to issue. You're going to be probably more likely to be able to raise venture capital funding. One thing that I think is really important to a lot of the people in this room, that when you're a first-time founder, patents, again, do have an effect of being a way to show investors, customers, and other stakeholders that you have the ability to move forward and to build your company. And that there have been academic studies that have shown that inexperienced first-time entrepreneurs are benefited even more by seeking and developing and building an intellectual property portfolio than experienced investors, because when you don't have a track record to run on, you need to go out and do things that build your credibility. Clearly, the first things in that space is not necessarily filing patent applications. It's, again, building the technology, building your product, finding product market fit, potentially developing revenue and building customer relationships. But alongside that, building an appropriate intellectual property portfolio will help you along this path. And one of the reasons why patents do such a good job at this is because, again, they mitigate the information frictions between startups and investors. When you have a patent, like I said before, it reduces the need to hold back information from investors or potential partners, because, again, you have the ability to claim it and to get patent rights and to exclude others from using the technology that's in the claims that issue. And again, it does have an outsized effect on your ability to file an initial public offering. And we'll see later that there's a lot of data around companies that go public and what their patenting strategies look like and when they go about doing that. And I think that that's important as part of this process to bear in mind that you don't have to necessarily do everything up front, and that there are ways to build your portfolio and develop your IP in a way that does it without expending too much effort, expending too much money at the early stages, so that you have a ground base to be able to build a larger portfolio that allows you to get to an IPO. So another way that you can raise money, and I think that's very common amongst academic entrepreneurs. So if there's anybody in the room that's commercializing technology from CMU or another university, is SBIR funding from federal agencies. And patents are usually a key criteria as part of that process for a number of reasons. One, Carnegie Mellon is not in the business itself of commercializing the technology. They need to have an asset that they can transfer to a startup that's going to take it and commercialize. One of the ways that they build that asset is by filing and prosecuting patent applications. And at the same time, the reviewers of the SBIR proposals are looking at what your portfolio looks like as far as one of the things that they care about in giving you money. Early stage, and this data, and I'm looking at this maybe a little bit dated, but you can ultimately raise hundreds of thousands of dollars in a phase one. You can raise upwards over $1 million in a phase two. And it can be, again, a key component to the process of raising money this way. One great thing about SBIR funding is that it's non-dilutive. And so you can get this money without affecting your cap table. And again, like $1 million this is dated a little bit. I'm not sure if it's risen. I haven't paid too much attention. Is it 2 now? Okay. So you can raise even more than this. So you're talking about 6-figure numbers if you can fit your technology into a proposal from one of the agencies. Right. And then, yeah, NIHs too. Again, it sounds like you might have a better read on this than I do at this point, but there are different values for different companies or different agencies. Looking at the ways that you can use patents as loan collateral. Again, patents do have the attributes of property, and there's strong bankruptcy protections that lessen the risk of lending to companies that file patents. Without going too deep into this, because this, again, is usually something that will happen later in a company's lifetime, you get better and more attractive borrowing rates from lenders when they have a collateralized asset. It's just like rates for mortgages on houses are typically lower than unsecured credit cards. Same thing with using patents to be able to raise debt. And interestingly as well, there are academic studies that show a correlation between patents pledged as collateral and increases in firms' R&D expenditures. So some companies are actually using their patents to drive and fund R&D expenditures. So their research and development efforts are actually then being put into an asset that is being collateralized and used to develop money streams in order to fund further R&D. So an example in this case, and I was just looking through patent records to find companies that had pledged their portfolios and ultimately raised money. So Mimosa Networks in 2014 raised money from NEA and Oak Investment Partners. They then assigned a security interest to Ally Bank, presumably in order to be able to raise and get more funding. And then later, again, it was a short-term situation. They then were sold to Airspan for an undisclosed sum. But this is a very common scenario where you can use your patent portfolios at the later stages to obtain bridge financing that allow you to get across the line, either to an exit or to your next financing round. And this is something that's becoming more and more common. I mean, going back 30 years ago, pledging patents as collateral was something that was very uncommon. But looking back to 2010 in this study, it had grown somewhat exponentially. looking at the next period, there were over 400,000 patents with a pledged security interest between 2016 and 2019. Numbers still going up. So it's becoming more and more common. So keep this in mind that the patents that you write and develop today and the portfolios that you build and develop today can be used later on as a way to fund your company through this mechanism. So joint ventures, this is something else that potentially goes down the line, will be there for you down the line, potentially even earlier for you as well. And typically, as I mentioned before, each company that's a party to the joint venture contributes something of value to a newly formed entity. And then each company provides access to capital, technology, management, and IP rights. But if you don't have these things, you're not going to be able to find and develop joint venture partners. So if it turns out that a joint venture is in your future and is something that's going to advance your company, the IP rights that are contributed to that joint entity is something that typically becomes an important part of that process. That said, and a caveat is that if you end up getting into a joint venture situation, care should be taken when you form those relationships to make sure that you have access to the rights that you need, that the joint venture has access to right it needs. You don't give up rights that you're not intending to as part of that process. So find a good lawyer and work with professionals who have engaged in those transactions before. Cross-licensing. Diving deeper into this again, cross-licensing is a situation where counterparties license their technology to each other. There are a lot of examples of this, particularly in the tech space. I mean, Google and Samsung have a broad cross-licensing agreement for patents related to the Android operating system. Being the two largest developers in that space, it makes sense. There's countless other examples of companies that develop cross-licensing relationships. Patent pools, like where there's multi-party portfolios of patents, often standards essential patents. So if you end up using Bluetooth in your technologies, you will likely have to take a license, from their SEP in order to be able to build what you're building. But the benefits to developing and using cross-licensing relationships, you can bundle complementary technologies, you can enhance interoperability between different kinds of technologies. It can allow you to access markets and monetize your unused or underutilized assets. So if you end up pivoting later, but you have something that is core to a standard, you can contribute it over there and basically use that process as a way to develop money for your company. And also it can lower development and production costs. If you have access to something that someone else already built, you don't have to go through and reinvent the wheel and build it yourself. That said, cross-licensing schemes can also create extra administrative headaches. So because you're going to have to comply with the terms of your license and manage it appropriately. On the startup side, it can be a barrier to entry and receive regulatory scrutiny from an antitrust perspective. So if you don't have well-developed IP rights, they're not going to have something of value to cross-license to another party. And if you don't manage it appropriately, there are antitrust risks associated with cross-licensing schemes. So if you tie it to an unrelated product or other things that violate the antitrust laws. Another mechanism that you can use to drive money or drive value from your patent portfolios or other IP rights is field of use licensing to other markets. If you're developing a technology for a product for a specific market that you're going to enter, but if it has applications to other markets outside of your primary market, because again, patents have the attribute of property, you can actually specifically license your technology and limit it to other fields. And so a very common place for this is in magnetic resonance technologies, where medical device companies that build MRI machines license their MR technologies for oil and gas exploration. And so that's one example where those companies are building and developing revenue streams from something that they're not interested in exploiting at all, but their patent rights actually cover. And IP licenses drive a lot of revenue. I mean, in the modern world, this was a survey from 2022, but when they talk to these professionals, and admittedly, these are professionals that work in patent departments, mostly of larger companies. On average, their companies were spending over $5 million a year in license fees. And so the acquisition of patent rights from major companies is a big part of their budget. And it's something that you will potentially be able to also share in if your company is developing its IP appropriately. Um, and I think maybe what's most important and what can be most important at the earliest stages of your company is that patents can encourage customers to purchase. As I mentioned before, patents can be an indicator of quality in your product and in the marketing of your product. It can provide some assurances that your product won't become obsolete due to a competitor, because again, if you have issued patent claims that are properly protecting your technology, it's a negative right that excludes others from using it. So they're going to have to come to you, and you're going to be able to use the monopoly profits that you're obtaining from your technology to keep your business operating. And then it also reduces the risk of customers actually infringing a patent, because if they buy from you, they have a license, and, or they've extinguished the rights of the patent for that product. And this, again, becomes critically important in certain industries. It becomes very important in patient industries such as pharmaceuticals. And there's also patent indemnifications in the Uniform Commercial Code for goods that are sold. Piggybacking more also off of cross-licensing, defensive portfolios. So building portfolios not necessarily in a way that you want to enforce them on others, but as a way of basically building up a shield so someone doesn't want to sue you, can be a very effective way of getting into negotiations if you're ever threatened with a patent infringement suit. One of the reasons why companies, especially larger companies, build up their portfolios isn't necessarily to go out and enforce them, but to give pause to another party who has patent portfolios of suing them. So again, like, they can be a bargaining chip. If someone sues you for patent infringement, you can say, okay, I'm going to sue you back. You may be able to get better settlement terms in your negotiations. It may lead you to the opportunity to cross-license technology. Again, if you have a portfolio that's defensive, it can be an inducement for them to want to come and license with you. It also may, again, counterclaims if you actually do get sued, and prevents the competitor from obtaining exclusivity for their development. So if someone builds on top of what you've already built, they're going to have to come back to you for the rights, as well as their customers potentially as well. And we put this slide into this presentation partly just to show that the major software companies are very active in this space. So if you ever end up getting really deep into IP policy, you'll see that there are commentators that will not be terribly excited about the way that Google or other large tech companies lobby Congress and the USPTO and the way that IP policies and laws are implemented in the US. They're still going out and obtaining large numbers of patents. So, I mean, Google is obtaining tons of patents. They care about it in their diligence process. If you look at a company like Samsung, Samsung is one of the largest, if not the largest, filer of patents in the world. So where does this all go? And so you actually build your portfolio, you're building a venture-backed startup, you're trying to get it across the line. What does this mean for you, and when should you be filing? So to kind of read into this, we pulled data from one recent M&A transaction, as well as I looked at a number of IPOs from last year. So the headline here is that the recent exit data shows that IP is a serious consideration for companies when they go to exit. So the ones that I looked at, Darktrace, when it was acquired by Thoma Bravo, which is a private equity firm last year. And I also looked at the IPOs of Rubrik, Service Titan, 20AI, and Reddit. They're not all the same, and they didn't use all the same strategies. But if you look through the their filing documents, if you look through their actual practices when it comes to protecting and developing their IP portfolio, it was a key consideration, and they made very strategic decisions in their process of going to exit. So looking at Darktrace. So Darktrace is a cybersecurity company that was founded in 2013, and they use machine learning techniques to detect potential threats. The company ultimately went public in 2021. Last year, it was acquired by Thoma Bravo. But what's interesting is looking at this graph. And so you're going to see this graph in the next few slides. What's probably the most interesting here is the blue spikes. And so what you can see in this, you can see that they started filing, like the company didn't exist before 2013, so there are no patent filings, nothing had issued. They started filing early 2014, 2015, 2016. They went public on the London Stock Exchange in 21, and lo and behold, in 2019, there's a giant spike in patent applications. And the question you might say is why? And it's because the investors, particularly in the public markets, tend to care very deeply about seeing strong IP protection for these companies. And there's, having been on investor calls, having worked with corporate development groups, it's something that I've seen this activity anecdotally firsthand, and it bears it itself out in the data. So they go public in 21. They're still filing. You're seeing issuances happen. Then they're looking to go private. And in 22, all of a sudden you see another spike. And I bet, even though I don't have any personal knowledge of their trajectory, they probably had hired an investment bank and told them to go out and do that. And that they started filing more patent applications. And now looking back at the quality of this and what you should be doing in order to set yourself up, I also imagine because they've been in this for a while and they'd started looking at strategically building out their portfolio, they had started laying out the groundwork of developing an invention disclosure process, understanding what would drive value for their customers, what the competitive landscape looked like around them, and they started making decisions about filing patent applications based on that information. So as an engineer, as a business professional who's looking at to build assets, you should understand what the competitive landscape of your company looks like, where your rights may read on, and be able to prevent others from coming into your space, but then also think about the interests of your investors. So ServiceTitan is a cloud-based CRM company. I mean, this is essentially like a pure software company. And so what you're going to see compared to Darktrace, who had a much larger portfolio, when ServiceTitan started to look at going public, they, though, too, started looking at filing patent applications and making decisions around building out a portfolio that would be attractive to public investors. So in most S1s, there are sections that are specifically related to IP and patent filings. But what's interesting, again, when you look at this data, they started to look to go public in 2022. So their spike in patent applications happened in 2020 and 21. They ultimately decided not to go public in 22 because it was a terrible market to go public back then. But they ultimately went public in 24. And they went from basically having no patent applications or maybe one or two to having a portfolio of about 14 issued patents by the time they actually they hit the market. So Pony AI was another tech company that went public last year. They're an autonomous vehicle company that's split between China and Silicon Valley. Again, like you can see, like they also only started early in like 25 or 2015, 2016. But because they're in the AI space, it's deep tech space with hardware, they were filing more and their portfolio is substantially larger. In 2020, they received an investment from Toyota, who put $400 million into the company. And you can see one of the things that they did after that was to file a lot of patent applications. As part of that process, again, they also had a spike of patent application filings in 22 when they started to look to go public. Related to the SPAC route, they decided not to go through that at the time when that market collapsed, but ultimately went public on the NASDAQ late last year. Yeah, go ahead.
Across all these graphs,
Yes.
The number of issued patents seems to drop over time. Is that just because patents take a long time, or are they filing?
That's exactly right. So what's happening in what you're seeing in this data is that it usually takes 3 to 5 years.
Yeah.
For something to issue. So what this graph is showing in that yellow line is that's the percentage of patents that were filed in that year that have actually issued.
Right.
And so you would expect that it's going to drop off over time, and the highest number is going to be the earliest stages.
Yeah, okay.
And it's going to go down. The other thing that you're seeing here too that I didn't dive into before is that most patent applications are not published for 18 months after they've been filed. So you're going to see lower numbers of patent filings in like 2024 and 2023 because a number of them still haven't been published yet.
Okay.
Yep. Okay.
What is the average cost of registering an IP?
It depends on what type of IP you're developing. I would say, like, to get all the way to issuance, I mean, usually I would quote someone for a patent, you're probably talking $15,000 to $30,000 in each jurisdiction. As a ballpark, it can be less, it can be substantially more. It depends on how much effort has to go into that process. Trademarks are substantially cheaper. Industrial design rights are substantially cheaper as well. But looking at that number, if you have to spend $30,000 each time you file a patent application, you need to be mindful about it. Make sure that you're getting the requisite value from filing that patent application, because if you start filing multiple or in multiple jurisdictions, it can be very easy to have your costs balloon to a place where that marginal 10, 20, 50, $100,000 would be better spent in another way. So while this is all important, don't take your eyes off of the fact that you need to be, that this is one piece of the puzzle to help build your business to success. Oh, yeah, sure.
Sorry.
No.
What kinds of software solutions still qualify for IP license?
Okay, so again, like there's a multitude of different types of intellectual property rights. And so in software licensing, there's usually a bundle of rights that go with that. Number one will usually be some sort of like copyright license to the source code of the instance. If it's cloud-based software, you're not actually obtaining the source code itself or running object code of your program. You're getting basically an access right to someone else's server. And so like any commercial software has licensing terms associated with it. The question is which IP rights are built into it. And I think if the question is asking more specifically about whether software is patentable, it is. Usually competent patent attorneys are capable of drafting claims that will get through the patent office. And if you look at what Meta's filing, if you look at what Google's filing, if you look at what other large software companies are filing, you're going to see them obtaining large numbers of patents on software specific technologies. And ultimately, I'm going to be very reductive about this right now. Usually you have to either show some sort of improvement to the operation of a computer, or it has to have some sort of physical manifestation in the claims. So yeah, so I think we went through everything that I had to talk about with 20AI's portfolio. So the last IPO from last year that I wanted to talk about, and I think that this kind of starts going towards some of these other questions. So Reddit went public last year, and Reddit on the other side of this equation does not have any patent filings. I mean, or if they do, they're minimal. But they had a lot of IP issues, and there was a lot of IP information built into their S1. And when they went public about a year ago, they understand that IP rights that are baked into their platform are extremely important, and they're becoming even more important as generative AI becomes a larger part of our daily lives, and large language models need data to ingest in order to perpetuate. So, I mean, and they said it straight out, quoting from their S1, we believe that intellectual property is an important part of our industry and business. We rely primarily on a combination of copyright, trademark, and trade secret laws, as well as internal security controls, confidentiality procedures, invention, assignment, and license agreements, and contractual provisions to establish and protect our IP rights in the United States and abroad. And I think that this is also critically important. And while I focused a lot about patent rights in this discussion, that it's not the only way to protect what you have. And depending on your business, the other flavors of intellectual property and the other intellectual property rights are going to be even more important. And so to that end, Reddit made $200 million in just licensing its data to AI providers. And that was leading up to its IPO. So that's only through March of last year. I haven't dug too deep into their financials since then. I'm looking forward to doing that. It would be very interesting to see how much revenue they're getting now. And because I'm sure it's only gone up substantially. On the other side, patents became a headline issue leading up to their IPO. So going back to thinking about how IP can sink your company or how you can actually get into trouble. Right before their IPO happened, it came out that Nokia sent them a complaint for patent infringement. I believe that's all still pending. There doesn't seem to be much in the way of public information on this at the moment, but it was an issue. It certainly came up to the minds of public investors that were looking to purchase share prices. And it may become an issue to anyone here too, if you end up in any sort of diligence with any sort of investor, whether it's angel investors, early stage or later stage venture capitalists, or when you go to the large banks and the large institutional investors who end up purchasing shares at an IPO. So now we've talked through all really these larger strategies. How do you make informed IP decisions? And I think that there's been a lot of discussion in other Connects lectures leading up today about how you manage the tactical aspects of it. But we kind of we like to sort of think about this again in a way to try to put it all together as part of your total business strategy. There's a large large number of different types of IP rights that are critical to your businesses and that we've seen have had outsized effects on the companies that went public and are acquired last year. Make sure you know how to manage each of these and which ones are important to your business, and then building strategies to enhance the value of them. And this is something that Sri and I developed back when we were working together at BlueTree, and that he's still implementing today as part of his due diligence strategy as far as investing into companies. So when you're thinking about it as an entrepreneur, again, look at who are the most active investors in your industry and your geography, and what do they care about for companies like yours? How often do their portfolio companies file patent applications, and like when and why are they filing patent applications? Because that'll be an indication as to when you should think about it and when you should be considering doing it yourself. Do valuations in your industry or geography differ based on size of the patent portfolio? And there's a lot of interesting data here too if you start going through the academic literature, if you start drilling down in information that you can find in CB Insights or even Google Patents. But again, venture-backed companies tend to patent more than other companies across disciplines, whether it's software, whether it's hardware, certainly in the life sciences. Presumably that's one, because they actually have capital to do it, but two, because their investors care and they put an emphasis on it. And again, I think, harking back to what I discussed all the way at the beginning, is that patents tend to be correlated with positive outcomes, both with receiving investment and getting acquired. And so on exit acquisition, I didn't really touch on this too much earlier. One of the reasons and one of the drivers behind getting acquired is that the acquiring company may just want your IP assets and to roll it up into their business. And it's a very valid reason and very valid strategy for building and thinking thoughtfully through how you build your patent portfolios. So again, there's no single best strategy here. And other than maybe talking to your counsel and thinking through these things early and making sure you protect what's valuable. But it's really business dependent, company specific. And when you're the entrepreneur, when you're the business person, when you're in control of your company, you need to own your business strategy. And as part of it, you need to own your IP strategy. And ultimately, if you do align your IP strategy with your business strategy, it can and it should, and if you do it right, it will lead to better outcomes as far as your enterprise value, your ability to attract customers, and lead to better business outcomes. So with that, I've already gotten some questions. My contact information is on the left. I usually do this talk with Sreekar, who's the managing director over at BlueTree Venture Capital. He invests in early stage and Series A, mostly software companies, but technology companies in the Midwest. If you have questions for either of us, please feel free to reach out. I'd be glad to take more questions now or discuss anything that was in the presentation. And I'll hang out to talk with anybody afterwards. Thank you.
I have a
Sure.
question. So for those, well, my name is Nick. I'm a faculty here.
This is me.
One of the things that we have here at CMU is, especially for those of us who are doing research,
Yes.
is we are developing IP, some of which may be patentable. We work with our Center for Technologies.
Yes.
Transfer CTech.
Yep.
I'm curious though, what is the view of say venture capital in say developing, having IP that was developed at say CMU that I worked with,
Yes.
CTech, and arguably there's, I have some rights, they have rights, is that looked on, how's that looked at in regards to sort of like VCs?
So I think generally, I mean, it's a good thing. So I want to say it like as a threshold. I mean, like, where is there the talent to develop the technology that you're developing? And I'm guessing, without knowing which department you're in, there's a large concentration of that in academia. And so I think, particularly at universities that have a strong track record of research, have very strong technology transfer offices, and I think Carnegie Mellon is one of those, that is generally seen as positive. I think that there sometimes are frictions between certain venture investors and academic tech transfer. I think that without touting Carnegie Mellon too much, I think that in a lot of ways, they've done a very good job of trying to mitigate those frictions. And so like you will certainly see some investors who don't like working with tech transfer offices or would rather, all things being equal, not have to deal with a tech transfer office.
Sure.
That said, I think generally it's positive because there's already been so much investment into the technology itself, into the people that are building it. I mean, you have a competent tech transfer office that's helping you and assisting you build your IP assets along the way. That usually can lead to better outcomes. And so I think that there are some, there isn't always an understanding on the other side, on the venture capital side, of what tech transfer offices do. And you'll definitely see things in the ether where there are people that are negative about tech transfer offices. And so one of the things that I try to tell people who I run across who are developing things in your space is, one, develop a good relationship with your tech transfer office, because they've done this a lot. And particularly if they're competent, and again, I think that CTech is one of those offices, they should be a net benefit to you. And then also, if you're looking to raise venture capital, it can be helpful to find venture capital investors who are experienced in investing into companies that are university spinouts, because they may have relationships with your tech transfer office. They may also be more likely to understand the particularities of what those universities need to see in their licenses, because they're different. I mean, like they have different requirements. There's federal regulations that require universities to do certain things in their licenses that you would never see in a purely commercial license. And if you don't understand that, like, you'll see people balk and throw up their hands and get really worked up about it. In reality, if you've done a lot of academic licensing, or if you understand academic spinouts, it's just part of the business. Yeah.
Is the best strategy to file original patents as general/broad in this law that you?
I think that that's a good idea a lot of times. I mean, I think that filing provisional patent applications is a great tool. I mean, it can be cost effective. You don't necessarily have to have claims. Really, it's about getting a filing date and then having an antecedent basis in order to be able to draft claims in a non-provisional later. So yeah, because it gets you filing dates. It can be cheap. It can be cheap. There's also strategies that can allow you to use that to kind of extend your term of protection later, depending on the way you can claim back to it. So yeah, I think generally yes, and as long as you have something that will be enabling and you can claim back to it later, yes. Yeah.
More about know-how and trade secret.
Sure.
I guess trade secrets is more like a Coca-Cola or formula, right? What about?
Yeah, and so I mean, so trade secrets very simply is information that has economic value from being secret. And so almost anything can be a trade secret. Something that's not patentable can be a trade secret. So like one reason why people may decide to go down or exclusively use trade secrets as opposed to exclusively using patents, and they're not necessarily mutually exclusive, is that you have something that's maybe not patentable. Like you have a software algorithm and it's really going to be challenging to get meaningful patent protection on it. But it's something that you have a cloud instance, no one's ever seen your source code. You've got contracts with your employees that prevent them from disclosing it. You've built your system in such a way that no one's going to actually see the underlying source code with your algorithm in it. That's a perfect example of when and how someone uses trade secrets. Yeah. Right. Yeah. And so, I mean, like oftentimes, I mean, in licensing agreements, you're going to see terms like that in employment agreements, especially. Like this is where like the worlds of intellectual property law and employment law meet. Like employment contracts, independent contractor agreements will have confidentiality, non-disclosure terms in them that cover these instances. And thinking about cost-efficient strategies to manage your IP to get to exit, those things are critical. They always come up in diligence later in either venture capital investing or like if you actually end up going through M&A, particularly with large companies, they're going to care about what your employment contracts look like, that if you hired your buddy to be to help you build part of the system, that you have it documented and that they've assigned their rights to the company and that any trade secrets are protected by that contract. And then on top of that, that if you actually are trying to rely on trade secret protection, that you have some mechanisms in place that are reasonable to protect the unauthorized disclosure access to it. Because for example, if you put your source code up in a GitHub repository that's public, it's not a secret anymore, right? And so like the interplay also like open source licensing strategies are, using open source projects are critically important, and you should be, if you're going to go down that road too, make sure that it aligns with your business strategy. And so like there isn't like a one size fits all decision process. Yep.